Hi viewers, as you well aware that I am Dr. Jetling Ellosa, running a YouTube channel called Law Speeches in English, Nyaya Prasanga in Hindi and Nyaya Prasangalu in Telugu languages. It is a multi-languages channel and I am regularly posting my lectures on various aspects and gamuts of law as well as world affairs. I request all of you to subscribe my channel and enhance your the knowledge. So today we discuss another topic, that is the prison and prisoners' rights in India. You know that a person commits an offense, he violates any sort of criminal law, he will be arrested. For that we have criminal administration of justice laws are there in our country, like the Bharatiya Nyaya Samhita 2023. Before that we have the Indian Penal Code, CRPC. So if a person is arrested, then his movement will be stopped. So what kind of rights he has? All those things we will discuss today's topic. You know, India is the second largest country in the world. If you see the other side, we have the written constitution, which is the largest constitution and lengthiest constitution in the world. And we have largest bunch of legal regime is there. So society is being regulated by the laws. Then prisoners also have been regulated by certain laws. If you refer to the statistical data in India, 2023, there were 5,30,000 prisoners are languishing in the jails, in prisons, in which 74% of prisoners are under trials, means they have facing the charges. Remaining 25% of the prisoners are convicted persons. Out of that, 4% are female prisoners are there in our country. And you could see, if they go to the Western Hemisphere, like United States of America, which is one of the notorious states for prisoners are concerned, there by 2024 statistics are concerned, there are 18 lakh prisoners are languishing in the United States prisons, though they have the population of the 33 crores. So it shows that we have lesser crime rate than the Western Hemisphere is concerned. And it also shows, reflects that the criminal system, the many criminals are escaping from the laws. So if he goes on to discuss the statistical data is concerned, there are basically, the Rajasthan has the highest number of prisons. Totally there are I am quoting the data of 2023. Total there are 1,332 prisons are there spread across our country. Basically, prisoners have been divided into three categories, the prisons. The number one prison is called as a sub jail. The second category is the district jail, and third category is we called as a central jail. Means it all depends upon the value of the prisoners they are keeping in that place. In addition to that, we have brought certain reforms and we introduced the women jails for the specifically for the women, and also for the border schools. Open jails are there. In Telangana we have the Charlapalli jail is called as open jail, and in addition to that we have the special jails also be there in our country. So by 2023, yearly per annum, we are spending around 10,035 crore budget upon the prisons. Then we can go to what are the rights of the prisoners. If a person is arrested, the Constitution guarantees certain rights under the Article 21 and also 22 of the Constitution of India. So before embarking that, we have to know that the international covenants are international law. So, in the international sphere, we have the human rights document is there that we call as a United Nations Human Rights Document, UN, signed in Geneva in 1948. There also certain things regarding to prisoners have been added. Specifically, we have to go to the 1966 covenant called the International Covenant on Civil and Political Rights of 1966. In addition to that, we have the United Nations standard minimum rules for the treatment of prisoners, also be called as a Nelson Mandela Covenants. It was named after the former president of the Nelson Mandela of South Africa, and he was imprisoned for long time for the waging the independence movement in South Africa against the apartheid policies. So it was made. Then we have, in India is concerned, we have the Colonial Era Act is still there, that is the Prisons Act of 1894. Basically, this act provides the foundation for the prisons law and also how the prisons have to be managed or maintained. In addition to that, we have jail manuals are there. For every state has made a jail manuals to regulate the internal things which may happen, which is happening in the jails, the powers of the jailers, powers of the superintendents, then how they have to deal the matters. All those things have been there in the jail manuals. So every state has its own jail manuals. In addition to that, we have framed a model law to give the respect to the human rights. That is the Model Prisoners Act of 2023, which has been, we can say it's a comprehensive enactment to give a sort of respect to the human rights. Then we have the Constitution. Just I told you that Article 21 is there, which provides the rights of the prisoners, in not in direct manner, but though the article is a very small article, like no person shall be deprived of life or personal liberty except by due process established by law. That is a small article. But it has given meaning to the life and personal liberties. So Supreme Court of India has given landmark judgments and innumerable judgments are there. We can write upon number of books upon this simple Article 21 of the Constitution of India. We will discuss again later. Then we have the Prisons Act of 1920. This is another act made in the colonial era. Then we have the Transfer of Prisoners Act. So if a prisoner is transferred from one jail to the other jail, or jail to the courts, then what kind of things they have to observe. For that we have the 1950 Act is there, that we call as a Transfer of the Prisoners Act. And we celebrate the International Prisoners Day on every year on the 10th of August of every year throughout the world. Then we discuss the prisoners' rights in India with regard to constitutional and jurisprudence perspectives are concerned. Just I told you that Article 21, though small article, which has encompassing the basic rights of a individual human being. Without that, we cannot survive in the society. Like right to education, right to environment, right of family, right of children. So everything, what not, all those things which are related to the life and our personal liberties have been there in the Article 21 of the Constitution of India. So in that context, the Supreme Court number of times have included the major judgments upon with regard to prisoners in this article. So, human dignity is required. Maybe he may be arrested, he is behind the bar, but he should be treated in a fair manner, in a humanistic manner. So that is there in the Article 21 of the Constitution of India. Then the Supreme Court time and again has stating that right to human dignity is a basic feature, and also the protection of the against torture, inhuman treatment is to be observed by the state, and state has to provide the legal aid, and state has to see that there should be a speedy justice, and state has to see that there is a right to communication and the visitation of the prisoners, and right to fair disciplinary proceedings should be there, and right to reformation should be there in the prisoner's attitude is concerned. So right to dignity is concerned. There we have from number of case laws are there. That is the important case law is the Sunil Batra versus Delhi administration case reported in 1978 and 1980. There All India Reporter 1978, Supreme Court 1675, and again it is reported in the All India Reporter in 1980, SC 1579 page number. So in this case, Supreme Court held that prisoners retain all the fundamental rights except they are not allowed to go outside. Means So all the fundamental rights which are there available should be accorded to the prisoners. And a prisoner is confined in a solitary confinement. He should not be chained without his consent. If it is against to the principles of the Article 21. So, the Supreme Court also stated that, I quote here, a prisoner is a human being and does not shed his fundamental rights at the prison gate. So that is a very, very important quotation, remarcation given by the Supreme Court with regard to human dignity of the prisoners are concerned. Then the Supreme Court also given adult in the matter pertains to the right against the custodial violence. If the police or the persons responsible of his custody, they commit any excesses, then what about it? For that we have to see the Supreme Court another landmark decision like the D.K. Basu versus State of West Bengal, reported in 1997, volume 1, SCC, page number 416. So in this case, Supreme Court has clearly stated that custodial torture or deaths are clear-cut violation of the Article 21. And if a person is being arrested, they have to, law enforcement agencies, they have to follow certain mandatory guidelines. And they want to detain, for that also they have to follow the mandatory guidelines. If there is in a custodial death, the person dies, the prisoner dies, then it is a duty of the state to provide compensation to his dependents. So that is a very, very remarkable judgment was delivered by the Supreme Court in 1997. Then Supreme Court also stated that there should be a right to speedy trial, which also comes under the Article 21 of the Constitution of India. In a case called Husainera Khatun versus State of Bihar, reported in 1979, volume 3, SCC, page number 532. In this, Supreme Court has stated that there should be speedy justice. Justice should be delivered within certain specific time. It should not be delayed. And if there is a famous saying that justice delayed is justice denied, that should not be there. It is a mandatory duty of the state to provide speedy justice, and so by this decision, later the government has released a number of under trials who are languishing in the Bihar jails and also the other parts of the India is concerned. Then the Article 21 also says that it is a duty to provide the legal aid to the prisoners. So they have the entitled for the free legal aid, and that has been stated, upheld by the Supreme Court of India in M.H. Hoskot versus State of Maharashtra. The case is reported in 1978, volume 3, SCC, page number 544. So it is another duty is castigated upon the state if the prisoners are unable to engage a advocate, a legal practitioner, then it's a duty is there to provide the free legal aid to the necessary and needy prisoners are concerned. And it is also a constitutional obligation is vested in the hands of the state. Then there is Article 21, if we see with regard to prisoners' rights are concerned, which also says that the right to health and medical care also be a fundamental right to them. And for that also we have Supreme Court or Apex Court of the land has given a very remarkable judgment guidelines in a case called the Paramananda Katara versus Union of India, reported in 1989, volume 4, SCC, page number 286. In this case also, the Supreme Court has stated that the state, once it got arrested a person, confined a person, then it is a duty arises upon the state to provide, take care of the medical aid of the person is concerned. So they cannot deny the medical aid. If they deny, it is nothing but violation of the fundamental right. That was stated by the Supreme Court in this case. Then we have the one more case is that is the state of Andhra Pradesh versus Challa Ramakrishna Reddy, reported in 2000, volume 5, SCC, page number 712. There also, if the prisoners have been denied of the medical aid by due to negligence or any other reason, then it is a duty is there upon the state to provide the compensation to such affected prisoner. So negligence also should not be tolerated by the under any circumstances. Then the Article 21 also speaks about the solitary confinement and the death row prisoners. So a death row prisoners, generally they put into solitary confinement. For that also the Supreme Court has given a certain guidelines in a case called the Charles Shobaras versus Superintendent Central Jail. The petitioner is a notorious prisoner at that era. So in this case, the Supreme Court has stated that the solitary confinement can be imposed only if there is a extraordinary conditions, and it is a duty of the prison authorities to provide, take safeguards for such kind of the solitary confinement. Then we have one more case is that Shatrugna Chauhan versus Union of India, reported in 2014, volume 3, SCC 1. So here also the Apex Court has an occasion to discuss delay in the execution of the death sentence and the solitary confinement. So in this case, the Supreme Court clearly stated that execution also cannot be delayed. If it is delayed, it is a violation of the Article 21 because he was under solitary confinement. So within time-bound manner, the execution has to be made of. Then the prisoners, we could see that they will be handcuffed and they will be state officials or the jailers or to say jail staff, they use force against them. Is it permitted? For that also, it also comes under the Article 21, and Supreme Court has again stated that Prem Shankar Shukla versus Delhi administration in 1980 case in volume 3, SCC, page number 526. So routinely their handcuffing is violation. In the extraordinary conditions only they have to be handcuffed, but routinely they cannot be handcuffed, and handcuffing is not permitted. Then there is whether the prisoners' relatives, friends can visit them. For that also Article 21 provides the remedy. So that has been again stated by the Supreme Court of India in a case called Francis Corali Mullen versus Administrator, Union Territory of Delhi. The case is reported in 1981, volume 1, SCC, page number 608. In this case also, the Supreme Court has stated that as when you have detained, a prisoner is detained, then he could have access to his friends and family members. We can call it as in a mulakat. So the state cannot deny the mulakat to the the family members. Then we have to cover the prison reforms. You know, the world is changing. Still, we have the old archaic colonial made law is there, Prisons Act of 1894. That should be remote and new law has to be introduced. With that view, we enacted the model law in 2023. And even the Supreme Court in number of cases also held that there should be we adopt the new law, and the colonial era law should have to be removed, and we have making a new India. We are going into the Vikasit Bharat by 2047. So that is the reason, again 2016, the model prison manual was made by the government of India, and where there is it has clearly castigated accountability, responsibility of the custodians like the prison officers to implement all those things which have been narrated by the Supreme Court. So the Supreme Court also number of time and again times has stated that compensation as a remedy under Article 21. So if there is any violation of the prison rights, then the prisoners have the right of claiming the compensation. That also be there under the Article 21 of the Constitution of India. So that was upheld by the Apex Court in a famous case called Rudal Shah versus State of Bihar. Case was reported in 1983. If it is a illegal detention, even illegal detention also, the state is liable to pay the compensation. Then in one more case called Neela Bhati Behars versus State of Orissa, we reported in the 1993. So if there is a custodial death, then the Apex Court has stated that the person responsible for such a custodial death of the prison, head of the prison, jail, also be liable to pay the compensation in addition to the state compensation. So we have seen that prisoners also individuals, they are citizens of India. We could see lot of overcrowding of the prisons. So it is better why we should not adopt the system which is prevailing in the Norway, Sweden and Denmark, where in the Scandinavian countries, where open system of prisons have been running, and which is leading to a reformation of the prisoners. The prisoners have been greatly reformed by the system. This archaic system, a deterrent system, may be leading to a prisoner after his conviction, his term of the conviction completed, he comes out again, he will try. That should not be there. So it is better we have to adapt the Scandinavian system of the criminal prison system, and so that we can get a truly welfare state. So this is with regard to the prisoners and the brief history, and also constitutional perspectives as well as judicial perspectives on the prisons and prisoners' rights. So if you feel that my lecture is good enough, please circulate or share among your friends, communities, and make so that I can give more lectures. This is only meant for the enlightenment purpose only. So the society should be enlightened. Then only legal knowledge is required. Then we can attain the equilibrium of the society. So that is the only purpose of making this my lectures in my channel. So once again, I request all of you to subscribe to my channel. Thank you for watching my lecture.